Malab, there are two orders that have been issued by the state government. The first order, that is 4/1/2023, that has been issued under subsection 4 of section 3, which says that once the order has been passed by the authority, it has to be approved by the state government. The subsequent order, Malab, that has been passed, it has been passed under section 12, which says that after the report of the advisory board, the order has to be confirmed. So the first order is approving the detention order, and the later order is.
Where have you said so in your reply? You have stated these facts in the last paragraph of your reply. It should come in the first paragraph of your reply. Have you stated what you are arguing?
Stated that it was approved, Malab.
What it means?
Malab, that
what you have stated here gives a totally different meaning. You are saying government approved it on 4/11.
Malab.
And thereafter advisory board confirmed the order.
No. The procedure is like that, Malab. First, let me read out.
It is not confirmation. Government does not confirm. The approval after the advisory board is a different order.
Well, that is what has been done.
Where have you said so?
That is there, Malab.
Show it to.
I'll just read out, Malab. The copy of the order dated 4/11/2022 of the state government approving the detention order passed by the district magistrate is filed herewith as annexure R3.
Yes.
Thereafter, the fact was also reported to the central government, and the grounds of detention were referred to the advisory board as evident from respective letters dated 4/11/22 and 10/11/22. Pursuant thereto, in the report of the advisory board, after considering the entire material and record as stated herein above, gave its opinion that was sufficient cause for detention of the detainee, and hence the state government confirmed the impugned detention order.
Where is that? R6.
Well, that is there. May kindly come to page 101 of my reply, Malad, annexure R6. Malad. Page 101. I read, Malad.
Where is the advisory board order?
Malad, the report is sent of the advisory board that is not supplied, Malad.
What is the date? You must at least tell the date of it, when it was done.
Malad, it is stated here in Malad that whereas the advisory board constituted under section 9 of the National Security Act 1980 has reported that there is in its opinion sufficient cause for the detention of so and so, that is the petitioner.
Where is that order?
Well, that order is not supplied.
Are you not
that is to the government, and then after being satisfied by the.
Are you not supposed to produce it?
For the state government, for the sake of confirming the order under section 12.
So difficult even to get proper facts in these cases. Conditions are so poor. In fact, we have to argue with you.
Apologies, from the next time we'll make a table first paragraph.
Yeah, I have told this much earlier. How to draft also I have told.
I'll
make things out.
It is chronologically stated in the last para only. It ought to have been in tabular form.
This is all technical law. Every date becomes important. Yes, anything else?
Yes, Lordship. The government advocate has referred to the judgment of Ramanohar Lohia, whereas para 52 is very relevant, which states there are three circles. That is security of state, that is peace and public order, and against the particular. So this case nevertheless come under the security of the state or the peace or public order, Your Lordship. And Your Lordship, only two cases after the proximity of 2 years have been registered. There's already a remedy, section 14, that has been initiated for the same acts, Your Lordship. And in these grounds, I'm praying that the detainee may be released from NSA, Your Lordship.
We don't find any ground to release you.
Lordship.
The judgments that you have produced are not appealing to us. Ultimately, this is a case of preventive detention.
Yes, sir.
For purposes of preventive detention, there need not even be a single case against you.
My lords.
Correct?
Yes.
You agree?
Yes, I agree.
the court looks at is only whether there is subjective satisfaction of the authority in passing the orders of detention.
Yes, Your Lordship.
So how do we realize what is happening in the mind of the detaining authority?
From the facts.
We find out from the records whether there is application of mind.
Yes, Your Lordship.
Now, there are a series of cases that are lodged against.
Yes, Your Lordship.
Some are serious, some are frivolous, some are. That's all right. So that is what has prevailed upon the mind of the detaining authority to pass the order. As far as we are concerned, that is sufficient.
Yes, Your Lordship.
The judgments that are relied upon by you, we don't agree with them because it is not the subjective satisfaction of the court.
Yes, Your Lordship.
It is the subjective satisfaction of the authority. If the authority has applied its mind based on relevant material, it is sufficient. What is that relevant material? There are hundreds of judgments on that. Even in a case where you are in detention and you are not on bail, cannot be a ground not to put you under preventive detention. But the fact that you are in custody and not on bail, the detaining authority should be aware of it. If they are ignorant about it, that constitutes a ground to say non-application of mind.
Yes, sir.
So here, even though you are in custody, the detaining authority is aware of it. It is sufficient. So the detaining authority finds that it's not proper to keep you in the open because for various reasons. Therefore, the preventive detention.
Yes, sir.
So when there is proper application of mind and consideration of relevant material, it is not for us to say whether it is sufficient or insufficient. We are only going to say proper application of mind. That we feel has been achieved in this case.
Lordship. In that case, I
Because in one or two cases, what happens? That man is on bail. That fact is not known to the detaining authority. They pass that order. Even a small ground like that is sufficient to quash the order of detention. Because you plead there is non-application of mind. Why there is non-application of mind? Because you have not considered relevant material. The relevant material that he is on bail or not on bail was not brought to their notice. Then it defaults the order of detention.
Yes.
But here it is not like that. So you cannot contend by saying I am already in custody in some other case. So why do you have preventive detention? That ground it's already covered by
the judgment in the reference it is stated.
that is what we
Yes, Your Lordship. The last and most least thing I want to demonstrate that there is a copy paste order, Your Lordship. In one of the series of events, it is stated that कि हमारे ऊपर बलात्कार का आरोप. It is not. And if my lords considered it, and otherwise, if my lords are with the opinion that there is no merits in the case.
No, you tell us.
I praise for the withdrawal.
No, you tell us. How many cases are there against you?
There are 13 cases.
13?
Yes, sir.
ठीक है, वो बलात्कार का छोड़ दो. फिर 12 बचते हैं.
And out of 12, there is only 1 or 2 cases of serious nature.
Yeah.
And all are of under 3 years, Your Lordship.
No, that's what we said. There need not even be a single case against you.
Yes, Your Lordship. But
the law is not that criminal background नहीं है तो preventive detention नहीं कर सकते. ऐसा नहीं है.
Yes, Your Lordship. Only a single moment or a single case arises.
It is an apprehension because it is preventive. It is not that you are committing a crime. It is the preventive from committing.
In that scenario, I praise for the withdrawal. And if any case arises that there is a continuance of the order after the expiry period, then I praise for a.
It will be the same ground, na?
Then
you are going to continue the same ground. The grounds of detention will be the same.
But the presumption again and again arises with the respondent, Your Lordship. And it cannot be a sufficient ground here.
So you are given opportunity of making representation?
No, Your Lordship, the order has been served to the detainee. When it was served, I am not aware about it. Nevertheless, no dates has been mentioned in the reply as well, Your Lordship. When the order has been served. So there is no representation.
It is stated.
बताइए।
Stated.
Wait, बता दीजिए।
Answering respondent only some of the impugn detention or as well as
कहाँ
मतलब-
पढ़ रहे हो? जोर से मत पढ़ो।
page
मतलब
14
बोलो
of my-
कहाँ पढ़ रहे हो? फिर
page
हम भी पढ़ेंगे।
page 14 of my reply.
हाँ।
Page 14, my lord, third line.
Duly served on the petition on the same day on which he was arrested, that is on 2/11/2020.
Records से कहीं परस्यू नहीं होती थी।
R1, my lord, there are signatures bearing on each page, my lord.
Signature
The
without
detention order
a
on 2/11/2000. Is mentioned in the reply.
they are dot signatures only.
Page 18 onwards, my lord, there is signature of the petitioner on each page.
So served on him.
My lord. Sure.
It is what my contention was that when it was received to the jail authorities, when it was served to the petitioner, is nowhere mentioned. It is stated that कि हमने 2 तारीख को ही भेज दिया. आप 2 तारीख को detention का आपको representation आता है from the SP. So all of the sudden you have passed a detention order. Then again it has been served to the petitioner. When it was served to the petitioner, nowhere mentioned in these documents.
Here they say it was served on 2/11 itself.
They are just saying there is no remark over here. That's about my
But
contention.
here is seal है ना, थाना प्रभारी, थाना so and so. Jailer's seal is also
It
there.
has been forwarded on, yes, your lordship. मेरे पास वो copy नहीं होगी that the reply.
Also have the original record, my lord.
Always carry the original. Have you got the original? Huh? दिखाओ.
Just get it, my lord.
In the office. Let's see.
I told you everything last time.
Whether we have it, whether.
Original must be here for us to see. You're dealing with the personal liberty of a man who has not even committed a crime. You can't take things so lightly.
Otherwise, we have produced every single document on record.
Your record must be with you. You need not give it to us. But when we ask, you should produce it.
We have just.
Chamber में रख के क्या करोगे तुम? See, the sensitivity of the matter is that the personal liberty that you are depriving. A man who is innocent, you are preventing him from roaming around in society. So that is how we look at it. It's not a case where a crime is committed. He has not committed any crime. You are preventing him from committing a crime. Therefore, denying a liberty without becomes very important. That's why your reply is very crucial. Dates are crucial. Original documents have to be here.
We will mention it in the beginning now. And in a tabular form.
It should come chronologically like that. The state have filed the reply. We have heard arguments of the petitioner's counsel, learned counsel of the petitioner as well as the state. Thereafter, learned counsel of the petitioner seeks leave to withdraw the petition. Dismissed.
My lord, my humble submission in light of Karandeep Singh's judgment, if my lord feels appropriate to pass this order, the extension.
You can always come back. Extension becomes another order. No?
My lord,
They have to pass one more order.
My lord, we'll have to.
much obliged.